The Honourable Phil Goff.
Mr Chairman, the Labor Party supports the bail amendment bill, and we support it because the net effect of the bill is really to toughen the provisions for giving bail on the margins where people have the greatest likelihood of reoffending while on bail. Mr Chairman, this bill doesn't make a huge difference, to be absolutely frank about it. What we found in the Select Committee was that particularly with the reverse burden of proof being placed on the defendant, this might result in the need for another 50 jail beds, prison beds, being required. Something like, I think, 350 people a year might be affected by this. If you take that 350 in the context of how many people are granted bail, it's in excess of 91,000 people getting bail a year based on the 2009 figures. So we have a bill here that will make it more likely for a relatively small number of people not to be granted bail when they're accused of a serious offence. And I guess we should acknowledge that the Minister's bill makes some difference, as against her predecessor, Simon Powell, who brought in a bill in the last Parliament that had the net effect of influencing the imprisonment of 10 people a year. That was, as a well-known professor of criminal law said, simply window dressing. But I want to say to the Minister that it is a fairly soft measure. If you compare this, Mr Chairman, with the legislation that came in 2000, which I, as the then Minister of Justice, was responsible for, that saw a 200% increase in the number of people that were remanded in custody rather than being granted bail. So that 2000 Act, the Bail Act of 2000, made a huge difference. Before that, the level of offending on bail was pretty rampant. There needed to be a toughening up, and that toughening up occurred. But I want to say I'm not being particularly critical of the Minister, because if you look at the figures for the number of people that we remand in custody that have been charged with an offence, in New Zealand it's 43 per 100,000, and that compares with Australia, where it's only 30, the United Kingdom, where it's 25, and Finland, where it's 10. So in relative terms, our bail laws are reasonably tough. Having said that, why would this House want to support a further toughening at the margins? Well, the reason why we support a toughening at the margins, Mr Speaker, is that there is still too much offending by people who are out on bail. The level of offending judged over a period of time, 2006 to 2010, added up to about 17% of those on bail offended again while they were on bail. That's nearly 1 in 5. Now, a lot of those offences were relatively minor offences, but some weren't. If I look at the figures, for example, during that 5-year period, 23 people on bail, while they were on bail, committed murder and were subsequently convicted of committing murder. 21 committed homicide. 763 were found guilty of sexual offending at the time that they were on bail, and quite a large number, 7,140, were convicted of acts that were intended to cause injury. If you take those figures as a proportion of the 450,000 people that were bailed over that 5-year period, they don't seem a lot. But if you're the victim of that offending, or a member of the family of the victim, then that's very serious. And we heard cases before the Select Committee where families came along to the committee, absolutely aggrieved, and understandably so, that somebody who was out on bail for allegedly committing a relatively serious crime, again offended in a serious way while they were out on bail. And when you look at those figures, you say New Zealand still, Mr Chairman, Mr Chairman, we say that New Zealand still has to do better. 17% of those who are out on bail and still committing offences is a figure that is too high. So this bill works on a number of different areas. The first point that I want to make is an important point, and that there is nothing in this bill at all that removes the discretion of a judge to grant bail. And that's important because every case is different, and there has to be a flexibility on the part of the judge to look at all aspects of the case to make a decision, rather than the law being too prescriptive. So there is nothing in this bill that takes away from the discretion of the judge. But what it does do, by reversing the onus of proof, normally there is a presumption of bail, and that's important because for centuries our British system of justice has said you are innocent until proven guilty, and if you're innocent until proven guilty, then there has to be a presumption of bail. But of course nobody in this House, and certainly nobody on the bench, is naive about that. If a person has allegedly committed an offence, and one, they might present a serious risk of reoffending, or two, there is a serious risk that they may abscond, or three, there is a serious risk that they might interfere with witnesses, then judges use their discretion to say that person will be remanded in custody, they will not be released on bail. So that doesn't change. That is the main reason why judges, under the existing law and under the future law, will make a decision either to grant bail or to remand in custody, or for the defendant to spend some time on bail and maybe some time in custody. But there are 6 areas where changes are made. Firstly, if you are alleged to have committed murder, the most serious offence you can commit, there will be a reversal of the burden of proof. And that won't actually change things a lot on the ground. If you look at the statistics for those who are alleged to commit murder, 2/3 of them are remanded in custody anyway. But what this requires is the judges to look just a little bit more carefully at those that they might release on bail, albeit charged with the serious offence of murder. The second thing that it does is build on the list of repeat violent and sexual offences that I put in the legislation in 2000, where there will be a reverse burden of proof. The burden on the defendant to prove that he or she is not likely to offend, rather than the burden being on the police to persuade the court that they are likely to offend. So previously, if you committed for murder or attempted murder or manslaughter or sexual violation, wounding with intent, aggravated wounding or use of a firearm in a crime, then you had the presumption that the reverse burden of proof. This is added to by including other serious offences: sexual conduct with a child, kidnapping or abduction, aggravated burglary, assault with the intent to rob. And if you've been previously convicted of those offences and you're charged again with a similar serious offence, the reverse burden of proof makes sense. I have no objection to that at all. The second key area that it changes is in regard to serious drug charges, and we're talking here about Class A drugs. And the alarming thing about the statistics here is that of those charged with committing a Class A drug offence, 34% of them, while on bail, are subsequently convicted of another serious drug offence. And that is simply too high. More than 1/3 are convicted of a further drug offence, and that is another reason why in this area the reverse burden of proof can be justified. The third area relates to young defendants, and there's a strong presumption in the past that has been for bail for those that are 17, 18 and 19. When we considered the 18 and 19-year-olds, we considered that since they were adults in every other facet of the law, there wasn't a strong case for treating 18 and 19-year-olds different from any other male. In fact, the offending by 18 and 19-year-olds tended to be higher than in other age categories. So that presumption, strong presumption in favour of bail, is removed in that area. and likewise for 17-year-olds that have been previously imprisoned. They have a... Mr Chairman? Mr Chairman?
The Honourable Phil Goff.
Just to finish off, Mr Chairman, I wouldn't want to see 17-year-olds normally placed in jail if there is any alternative, because they are young and impressionable. But the statistics also say that if they're 17 and they've been previously imprisoned, then there is a very, very high chance that they'll re-offend, and therefore that presumption of automatic granting of bail should be removed. Mr Chairman, the other things are relatively minor. Changes in terms of police bail to bring it in line with court bail. That is supported by us. Giving a statutory basis to electronically monitored bail. The electronic monitoring has proven very effective in reducing offending for people while on bail. This gives a statutory basis to it. There's no problem with that. And some relatively small amendments that are made in relation to bailable offences that are bailable as of right, removing offences for a false declaration and providing the necessaries of life. Mr Speaker, Mr Chairman, the thing I want to finish on is to say this is a piece of legislation that is not radical. It has a relatively minor effect. I think it will be helpful. But if we really want to deal with the much wider problem of offending on bail, then we need to look at the delay in people actually having their cases heard in court, because if you're on bail for a longer period of time, obviously the offending on bail will go up. That absolutely has to be looked at. Mr Speaker, we need to look at I think you and I both sat in at the District Court in Auckland and watched the production line nature of bail applications being heard. Any assistance we can give to judges in terms of risk assessment tools would be important. And the other thing that I think is particularly important is that where decisions on bail are, in hindsight, wrongly made to grant bail, we need to have a better system of reviewing those decisions that the judges have got wrong. I am not proposing here an interference in the judicial independence. I'm saying that the head of bench should probably have a better way of reviewing cases where wrongful decisions are made to see what we can learn from those decisions to stop mistakes happening again. With those comments, Mr Speaker, we support this bill.
I call David Clendon.
Mr Chair, as we go through this, what I suspect will be quite a brief